If you own a home, there is one estate planning mistake that could cost your family tens of thousands of dollars, trigger a lengthy court process, and expose your entire financial life to public record. And here is the unsettling truth. Most American homeowners over the age of 55 are making this mistake right now without ever realizing it. You may have a will sitting in a drawer or a file cabinet, signed and notarized, and you might believe the document protects your home and your heirs. But that belief is dangerously incomplete. A will alone does not keep your home out of probate. It does not protect your equity from nursing home costs. It does not give your family immediate access to the property when they need it most. A trust, on the other hand, can do all of those things, and the difference between the two approaches is far greater than most people understand. In the next few minutes, I am going to walk you through exactly why putting your home in a trust beats relying on a will, and by the time we are done, you will know precisely what steps to take to protect the roof over your head and the legacy you have spent a lifetime building. Let us begin with the most common misconception I hear from seniors across the country. They believe that having a will means avoiding probate. This is simply not true. A will is a set of instructions for the probate court. Think about that for a moment. When you pass away with only a will in place, your will becomes a public document filed with the county courthouse. The court then supervises the entire process of distributing your assets, including your home. Your family cannot simply walk into the house, change the locks, and handle things privately. They must petition the court, wait for a judge to approve the executor, notify all potential heirs and creditors, and follow a strict legal timeline that can stretch anywhere from several months to well over a year. During that time, your home sits in limbo. Mortgage payments, property taxes, insurance, and maintenance costs continue to pile up. Your family must pay those bills while simultaneously dealing with grief, paperwork, and legal fees. Probate is not free. Attorney fees, court costs, appraisal fees, and executor commissions can consume 3 to 7% of the total estate value before your loved ones see a single dollar. On a modest home worth $250,000, that could mean $12,000 to $17,000 evaporating into the system. On a larger estate, the numbers climb even higher. And all of this happens in public. Anyone can walk into the courthouse and read your will, see what you owned, learn who inherited it, and discover details about your family dynamics. For many seniors who value privacy and want to spare their children unnecessary stress, this is a deeply unsettling revelation. Now, let us contrast that with what happens when you place your home in a properly structured, revocable living trust. You still own the home while you are alive. You still live in it, sell it if you choose, refinance it, and enjoy every right you have today. Nothing about your daily life changes, but when you pass away, the home does not go through probate. It does not get tied up in court. Your successor trustee steps in, follows the instructions you laid out in the trust document, and transfers the property directly to your beneficiaries. This can happen in a matter of weeks, not months or years. There are no court fees, no public filings, no attorneys inserting themselves into every decision. The savings alone can be substantial, but the emotional relief for your family is priceless. I have spoken with countless adult children who were shocked by how smoothly a trust-based estate plan worked compared to the nightmare they experienced settling a parent's probate estate. The difference is night and day. Beyond probate avoidance, there is another critical reason why a trust outperforms a will, and this one catches many seniors off guard. Incapacity planning. A will only takes effect after you die. It offers zero protection if you become unable to manage your own affairs while you are still alive. Imagine you suffer a stroke, a dementia diagnosis, or a serious accident that leaves you incapacitated. If your home is titled in your name alone, your family cannot simply step in and handle things. They may need to go to court to establish a guardianship or conservatorship, a process that is expensive, time-consuming, and emotionally draining. The court appoints someone to manage your affairs, and that person might not be who you would have chosen. They will have to report to the court regularly, seek permission for major decisions, and operate under ongoing judicial oversight. With a revocable living trust, you name a successor trustee in advance, someone you trust completely. If you become incapacitated, that person takes over management of the trust assets seamlessly, without court involvement. Your bills get paid, your property is maintained, and your dignity is preserved. This protection alone makes a trust worth considering for anyone who values autonomy and wants to shield their family from legal chaos. Let me address a fear I hear constantly. Some people worry that putting their home in a trust means giving up control or making things complicated. I want to reassure you that this is not the case. With a revocable living trust, you are the trustee while you are alive and competent. You control everything. The trust uses your Social Security number for tax purposes. You continue to claim your property tax exemptions and deductions. There is no separate tax return to file. The trust is invisible to the IRS in terms of day-to-day life. You can buy, sell, or refinance property held in the trust, though you may need to temporarily transfer it out and back in during a refinance, a simple step your lender can handle. The point is, the trust serves you, not the other way around. And if you ever decide you do not want the trust anymore, you can dissolve it entirely because it is revocable. You remain in the driver's seat at all times. Another powerful advantage of a trust over a will involves blended families and second marriages. Wills are more easily contested. A disgruntled heir can challenge a will in probate court, alleging undue influence, lack of capacity, or improper execution. These legal battles can drag on for years, draining the estate and tearing families apart. A trust, particularly one that is funded and managed during your lifetime, is significantly harder to contest. Courts generally respect the clear intent expressed in a trust document, especially when the trust has been in operation while you are alive and competent. For anyone with a complicated family structure, a trust offers peace of mind that your wishes will actually be honored. Let us talk about another scenario that worries many seniors: long-term care costs and Medicaid planning. I must be careful here to note that I am not providing legal advice, and you should consult an elder law attorney for your specific situation. But I can share general principles. A will does nothing to protect your home from being counted as an asset if you need Medicaid to pay for nursing home care. In many states, Medicaid can place a lien on your home to recover costs after you pass away. Certain types of trusts, specifically irrevocable Medicaid trusts, can shield your home from that estate recovery process if structured correctly and funded well in advance. This is a complex area with strict look-back periods and state-specific rules. But the key takeaway is that a simple will offers no asset protection whatsoever, while a trust may provide a powerful layer of security for your home equity. If preserving your home to pass on to your children is a priority, this is a conversation you need to have with a qualified professional sooner rather than later. I also want to highlight the practical nightmare of out-of-state probate. Suppose you own a vacation home in Florida, but your primary residence and will are in New York. When you pass away, your family will likely face two separate probate proceedings, one in New York and an ancillary probate in Florida. That means two sets of attorneys, two sets of court fees, and double the headache. If you place that Florida property in a trust, you eliminate the need for ancillary probate entirely. The trustee simply handles the property according to the trust terms without involving the Florida courts. This is a massive time and money saver for families with property in multiple states. Now, you might be wondering about the cost of setting up a trust compared to a will. A simple will might cost a few $100s, while a trust-based estate plan typically runs between $1,500 and $5,000 depending on complexity and where you live. That price difference makes some people hesitate, but I want you to think about what you are actually buying. The will saves you money up front and costs your family dearly on the back end. The trust costs more up front and saves your family thousands, sometimes tens of thousands, in probate fees, court costs, and lost time. When you frame it that way, the trust is not an expense. It is an investment in your family's future and your own peace of mind. And the truth is, probate attorneys are often the ones who benefit most when you only have a will. They bill by the hour, and they have every incentive to keep the process moving slowly. With a trust, you take that profit motive out of the equation. I should mention one more important detail that many seniors overlook. Placing your home in a trust does not automatically protect it from creditors or lawsuits while you are alive, because a revocable living trust is under your control. The assets inside are generally still considered available to satisfy your debts. This is different from certain irrevocable trusts, which do offer creditor protection but require you to give up control. The primary benefits of a revocable living trust are probate avoidance, incapacity planning, privacy, and ease of transition. Those benefits alone are enough to make it a superior choice to a will for most homeowners. Let me walk you through a real-life example that illustrates everything I have been describing. Consider a widow named Barbara who owns a home worth $350,000. She has two adult children and a simple will she prepared 10 years ago. Barbara believes she has done everything right. When she passes away, her children discover the will and take it to an attorney, who informs them they must open probate. The court process takes 14 months. During that time, the house sits vacant. The children must pay the mortgage, insurance, and utilities out of pocket while the estate is tied up. They spend over $15,000 on legal fees and court costs. At the end of the process, the house is finally transferred to them, and they sell it, exhausted and frustrated. Now imagine Barbara had placed her home in a revocable living trust. Upon her passing, her daughter, named as successor trustee, takes the trust document and death certificate to the county recorder's office and transfers the property directly to herself and her brother. The process takes a few weeks and costs a few $100s. The house is sold, and the proceeds are split without court interference. The difference in emotional toll and financial cost between these two scenarios is enormous. I want to be fair and acknowledge that a trust is not a magic solution for every single person. If you have a very small estate, limited assets, and live in a state with a simplified probate process, a will might be sufficient. Some states allow small estates to bypass formal probate through affidavits or summary administration. But for the vast majority of homeowners, especially those with equity built up over decades, a trust provides protections that a will simply cannot match. The question you should ask yourself is this: do I want my family to spend a year in court spending money, or do I want them to settle my affairs quickly and privately with minimal expense? As we wrap up, I want to leave you with a clear summary of what we have covered. A will alone requires probate, which is public, slow, and expensive. A revocable living trust avoids probate entirely, saving your family time, money, and stress. A trust protects you during incapacity, while a will does nothing until after death. A trust is harder to contest and offers greater privacy. And a trust can be a valuable tool for Medicaid planning when structured appropriately with professional guidance. The choice between putting your home in a trust versus relying solely on a will is one of the most consequential decisions you can make for the people you love. Do not let the upfront cost deter you from protecting everything you have worked for. Sit down with an experienced estate planning attorney, ask the right questions, and get your home titled into a trust if it makes sense for your situation. Your family will thank you, and you will sleep better knowing you have taken care of them in the smartest way possible. If this information opened your eyes to something you had not considered before, please take a moment to like this video so more seniors can find this content and protect their homes. Subscribe to the channel for straightforward, no-nonsense guidance on retirement, Social Security, Medicare, and all the financial topics that matter most as we age. And I would love to hear from you in the comments. Have you already set up a trust for your home? Or are you still relying on a will? What questions or concerns do you have about this topic? Share your experience below, and let us learn from each other. Your story might be exactly what someone else needs to hear today.